Good morning, everyone. This is Lina, welcoming you to our weekly Wednesday webinar. I hope everyone is keeping well. Today, our topic for discussion is the real estate in Malaysia. Is it a crash landing or a cash landing? So before we start, let me quickly introduce the Zaid Ibrahim and co-panelists. Our ladies-dominated real estate team across 8 offices in our country. Both Patricia and Angelique, they are based in Penang. Sunita in JB, Karen Lim in KL, and we have Datuk Paul Kong from Savills, our external speaker. Okay, we also have real estate specialists across our 9 other ASEAN offices. So if you want to reach out to them, just let us know. We will connect you. And I'm sure there are lots of opportunities across the ASEAN region at the moment as well for real estate. So let me quickly also introduce our external panelists. Datuk Paul Kong is the Group Managing Director of Savills. More than 25 years of professional experience in property profession in Malaysia. He's a registered valuer and estate agent. He specializes in corporate and litigation valuations and has undertaken many major corporate exercises and various submissions to the SC of Malaysia, Singapore, Hong Kong Stock Exchange for various purposes, including new IPOs and RTOs. He has also vast experiences in capital markets, investment transactions, international project marketing, office leasing, tenant representations, and various other sectors. He is a licensed auctioneer in the states of Selangor, Wilayah Persekutuan. He also frequently writes and comments on the property issues in the major newspaper and across, Southeast Asia. So let's get this going. Let me set the stage, okay? So Malaysia government basically, to us, handled and controlled the pandemic quite well. Compared to most of our neighboring countries. So to tackle the challenges posed by this coronavirus, we have introduced quite a lot of stimulus packages compared to the other ASEAN region. If we do a quick comparison, for loan moratorium, the countries that are implemented are Singapore, Malaysia, Philippines, and Brunei at the moment. So for Cambodia and Laos, there aren't any such, deferment payment for loans. For other countries that are not implementing, it's up to the banks to discuss and take, an approach whether they allow the moratorium or not. But so far in Malaysia, it's quite well. All this, whether it's going into MPL or not, it's going to only happen maybe in January next year, okay? So Malaysia is also one of the favorite investment destination for real estate, especially with such a volatile, political scene, especially in Hong Kong. There are a lot of investors coming to Malaysia, especially Hong Kong investors, to invest in the Malaysia real estate, okay? In terms of the lenders' reaction, financial institutions, they are still very cautious but remain supportive, okay, in providing financial, packages to some of the investors coming in from overseas. But basically, it's still very, very cautious. Hopefully, with the new stimulus package and HOC program and all that, it can spur a little bit of the property market. We see transactions coming in from the legal perspective or legal firm, slowly triggering in, but it's still not very optimistic. But hopefully, with the HOC, everything gazetted, everything settled, things can move quickly, okay? That being said, many economic sectors, including the real estate, will continue to bear the brunt. Hopefully, the second and third wave of the COVID-19 arrives and will not arrive, and the development of vaccine is quickly developed. Some housekeeping rules. If you have any questions, please post it at the Q&A box below, and we will take your question at the end of the session. Okay. Let me introduce Patricia. Patricia will briefly do an introduction of Malaysian real estate framework.
Okay, thank you, Lina. The Malaysian land system, except for Sabah, is based on the torrent systems, which the principles are embodied under the National Land Code. So under the torrent system, title or interest in land vests and divests only upon registration. The NLC creates a uniform system of law relating to land and land tenure, the registration of title to the land and the dealings in the land within West Malaysia. The states in East Malaysia, Sabah and Sarawak, are each governed by their own land rules. The National Land Code provides for each state government to draw up their own individual state land rules. So these land rules will outline the various procedures pertaining to land matters in that particular state. So, for land, it's either held under freehold or leasehold basis. So, for freehold land, it's held in perpetuity, which is a full and permanent ownership, and then until disposal by the proprietor. And it's usually not subjected to any restriction in interest. And then for freehold lands, this also includes private lease schemes, such as Medini in Iskandar and some very old developments in Penang. For these private lease schemes, essentially it involves the registered proprietor leasing the land to developers to develop and allowing the developers to on-sell the leases to the end purchasers. So at the end of the lease period, the land will just revert back to the registered proprietor. Okay. As for leasehold land, it's held under lease for a maximum of 99 years. And then the tenure is stated in the registered document of title. And usually it comes with restriction in interest. So typically the restriction imposed will include the land cannot be sold or charged, leased, or transferred in any manner without the consent of the state authority. So the proprietor of the leasehold land may apply to the state to extend the term before the expiry of the leasehold term. And then the extension may be subjected to a premium payable to the state. Okay. For category of land use, next slide, please. Thank you. Land use can be categorized mainly in for three purposes: agricultural, building, and industrial purposes. So each category of land use is accompanied by implied conditions prescribed by the National Land Code. The land must be used according to the category of land use, subjected to the express conditions and restriction and interest stipulated under the title. So failing which the proprietor may be subjected to fine or the land may be forfeited. So for buildings, it can either be commercial or residential use. So these are the typical type of properties under commercial and residential use, which includes shopping malls, retail lots, SOHO, SOFO, SOVO, condominiums, apartments, terraces, house, etc. And then for agricultural, it's for bona fide agricultural cultivation only. Sorry, next slide, please. Thank you. And it includes ranches, farms, rubber plantation. And then there should not be any buildings erected on the land for agricultural land, except for agricultural purposes. And then for industrial, this includes factories, production of distribution of power, storage, yards, and manufacturing plants. Okay. Basically, there are three types of titles under the torrent system, which are master title, strata title, and individual titles. So master titles refers to a bigger piece of land meant for property development, which has yet to be divided into individual parcel lot. So the title of the land will be registered in the name of the developers until the strata title or the separate individual title has been issued. So before the issuance of the strata title or the individual titles, the developers will be the registered owners and purchasers will be beneficial owners to the land. So for strata titles, it's actually subsidiary titles for each unit of parcels in the subdivided building or land. So developer will apply for transfer of ownership of the land. Each unit will have its strata title in the shared building or land. So the title to the land will continue to exist and vested in the management corporation after the subdivision of the title. These are typically for condominiums, apartments, townhouses, and landed gated community schemes. As for individual title, it's the owner has a discrete piece of land and they have an individual document of title to the land. It's typical for landed property like terrace houses, bungalows, semi-detached houses. Okay. Properties can be acquired by way of direct purchase from developer or newly launched properties, or buying from secondary market from existing property owners. Can I have the next slide, please? Thank you. Okay, for direct purchase, housing development sold by developers are governed under the Housing Development Control and Licensing Act. We call it HDA. And the Act provides a statutory contract for sale of property subject to the Act, and developers are bound to contract on these statutory terms. So direct purchase are rather straightforward because there's a prescribed format for the sale and purchase agreement where the developers have to follow. So here's an overview of how a direct purchase transaction will look like. So a buyer will decide to buy, okay, you look at the property development, you like it. So yes, I'll make the decision to buy and then proceed with the execution of a booking form. So usually the developer will have a list of panel solicitors, which they have already engaged. So you just choose from the list which you preferred and proceed with the signing of the SPA and pay the deposit. Like I said previously, for housing developments, the SPAs will be in a standard format. And then you'll also at the same time execute the related documents. Sometimes it includes deed of mutual covenants, power of attorney, or license agreement. So, okay, and then you apply for loan if you're taking financing, and also at the same time execute the financing document. Okay, the balance purchase price will be settled according to the payment schedule in the sale and purchase agreement for cash buyer, and for those who are taking financing, the financier will just release the loan according to the progressive billing. After that, after payment of the full purchase price, when the CCC, which is the certificate of completion and compliance, is ready, and together with the strata title, then the developer will deliver keys to the purchaser. And yeah, this is how usually a direct purchase transaction is transacted. Okay. As for a sub-sale transaction, next slide, please. Okay. For sub-sale transaction, the parties are free to negotiate and agree on the commercial terms of the sale and purchase agreement on an arm's length basis. So there's no prescribed format. So yeah. And here's an overview of the transaction. So you decide to buy, execute booking form, appoint your lawyer, and then pay the earnest deposit and appoint lawyer, and apply for a loan. If you are paying by loan, then you proceed with signing of the SPA and pay the balance deposit. Okay. If the property is subjected to existing financing, then you will release, the bank will release the redemption sum to redeem the property and to obtain all the discharge documents and original title. And after that, the bank will release the balance loan sum. And then both parties will calculate the apportionments and outgoings, and followed by the delivery of keys by the vendor to the purchaser. Okay. Yeah, that's basically how yeah, that's the legal framework of the real estate regime in Malaysia. As for acquisition of property by foreigners, foreign ownership property in Malaysia is quite liberal, where foreigners can actually own up to 100% of the property as long as the minimum requirements are met. So there are certain categories of real estates which are not eligible to be acquired by non-Malaysian citizens or foreign companies, which includes property built on Malay reserve land, low and medium cost residential units, and properties distributed to Bumiputra interest in a development project. For foreigners, under Section 433B of the National Land Code, a non-citizen or foreign company may acquire land or interest in the land only after the prior approval of the state authority has been obtained. Yeah. So the manner of implementation of Section 433B differs according to the guideline of each state. So each state has its own regulations as to the type of properties which may be acquired by the foreigners, the prescribed consent forms to be submitted to the state authority, the application fees, levies, and approval fees, if any. Okay. Foreigner who wishes to own real property in Malaysia will be subjected to the guidelines on the acquisition of properties set out by the Economic Planning Unit, EPU Malaysia, if the property transaction amount exceeds a certain threshold and there's a dilution in Bumiputra interest. Okay, next slide, please. Okay, here I can share with you some minimum threshold in the different states in Malaysia. What are the threshold for foreigner, MM2H holders, and PR holders? So in Penang, strata properties, the threshold for foreigners is 800,000 on the island and 400,000 on the mainland. And for MM2H, it's 500,000, and for PR holders, 250,000. These are still pending the government gazette. And for landed properties, it's 1.8 million on the island and 750,000 on the mainland, and then 1 million for MM2H holders and 250 for PR holders. Please note that this ceiling price is reduced for foreign home buyers in Penang. It's valid for 1 year, starting from 10th of June to 9 June, 10th of June this year to 9 June 2021. Yeah. Next slide. A minimum threshold in Selangor. For foreigners and MM2H holder, it's the same. There are 3 zones in Selangor. You can see from the slides, the different districts. So residential units for strata titles for foreigners and MM2H holders is 2 million for zone 1 and 2 and 1 million for zone 3. And there's no restrictions, no minimum thresholds for commercial units and industrial plot lands. Next. Minimum threshold in Kuala Lumpur, same thing for both foreigners and MM2H holders. Residential unit for landed and strata titles is 1 million, and there's no restriction, no minimum threshold for commercial units and industrial plot or land, and for PR holders as well. Okay, for Johor, foreigner intending to purchase a property in Johor are allowed to purchase the property directly from developer, includes residential units, commercial units, and industrial units. For industrial units, there's no restriction as to the numbers of units to be owned by the foreigners. And then purchase through a second-hand or sub-sale transaction. It includes residential units, commercial units, industrial units. Same thing, there's no restriction in the numbers of units. And then for agricultural land, it can only be by way of lease. Okay, next. The minimum threshold for Johor for all types of property, landed, strata, residential, commercial, industrial, agricultural, for both foreigners and MM2H holders, it's 1 million, and there's no minimum threshold applicable for foreign buyers in investing in properties in Madini. Okay, next. So these are the types of properties not permitted to be acquired by foreigners in Johor, which includes houses or shops under low cost and medium low cost category. single or 1.5-story house, single or double-story shop or office. The rest are the same for the rest of the states where properties identified as Bumi-Putra lots within the development, unless there's a letter of release obtained from the relevant authorities. And then land in an order for sale by the court or public auction, and then Malay reserve lands, agricultural lands, and properties gazetted under National Heritage Act 2005. Yeah, that's all for my sharing. Back to Lena.
Thank you, Patricia. Next, we go to Angeline to tell us or take us through a little bit of the government initiatives to boost the property market.
Hi,
Angeline?
everyone. Yes, hi. Okay, so the timing of this webinar is really good because only yesterday all these exemptions were published in the Government Gazette. So yeah, so I'll take you through the brief exemptions and for stamp duty and RPGT based on the Government Gazette, which was published yesterday. Can I have the next slide? Okay, so actually all these exemptions is under our 4th economic stimulus package, which we call Bencana, which is primarily aimed at helping businesses recover from the impact of the COVID-19 pandemic. Okay, so basically real estate is one of the many factors that drive our economy. And it has been always an issue that there's always been an oversupply, which is more than demand in regards to property. So the home ownership campaign, HOC, was actually introduced last year to address this oversupply, and it was reasonably successful. Many developers saw that their sales were picking up due to HOC. So that's why under Bencana, the government has reintroduced the HOC for 2020 and 2021, and it's applicable for purchase of residential property by individuals who are Malaysian citizens. And you have to buy from developers at the purchase price of between 300,001 ringgit to 2.5 million ringgit. Okay, and there's also stamp duty exemption for instruments of transfer up to 1 million and full stamp duty exemption for loan and financing documents. Okay, this is, you can, if you want to read more, you can actually Google the Government Gazette. The QA number is there and there'll be all the information in the Gazette. Okay, other conditions is that the developer has to provide a minimum of 10% discount on the purchase price, and the S&P must be executed between 1st of June and 31st of May next year. Okay, next slide. Okay, so for the secondary market, we also have an incentive for RPGT. The previous time the government introduced RPGT was back in 2007, and that saw a real boost to the real estate sector. So they have reintroduced this exemption from RPGT for disposal of residential property where the S&P or transfer is executed between 1st of June to 31st of December next year and stamped no later than 31st of January 2022. Okay, this is limited to 3 residential properties per individual and also only for Malaysian citizens. So foreigners are not allowed to utilize this exemption. Okay, so you can also read more in the Gazette if you wish under that POA number which is stated there. Okay, and then the next incentive is that you can get more than 70% housing loan financing for a 3rd residential property, which is only applicable to HOC properties. Okay, previously you cannot get, for a 3rd property, you cannot get more than 70%, but now you can get a loan margin of more than 70%. Okay, next slide. Okay, then some clients ask us, what about tenancies? Is there any relief for rental and things like that? So there is this special deduction introduced for corporate taxpayers and other taxpayers on rental reduction offered to SME tenants. So if you are a landlord of a business premise and you offer relief of rental, which is at least 30% of the existing rental rate, you are allowed to claim a special deduction equivalent to your rental reduction. Okay, so to be eligible, you have to be renting out your business to any qualified SME tenants and the tenant must be using the premises for carrying out its business. And the landlord, which is you, you have to be a taxpayer with rental income under the Income Tax Act. Okay, so these are some of the initiatives which the government has introduced to help individuals as well as businesses during this pandemic time. Okay, I think Dr. Paul later will elaborate more about this as well. That's all for my part. Thanks.
Thank you, Angeline. So this pandemic has actually caused a lot of business interruption, especially in the real estate sector. Contractors cannot work, developers can't sell. From our perspective, clients cannot sign sale and purchase agreement. So the next topic will be, is electronic signing or video conferencing signing. Is it valid in Malaysia? So let us welcome Sunita. Sunita, please help us to, elaborate and tell us what is the actual position in Malaysia.
Oh, sorry, I was on mute. Before I go into the consequences, the video conferencing or electronic signing, I'd like you to go into the consequences of the lockdown on the parties to real estates. I think most developers and lawyers and the buyers were affected by the sudden lockdown that was announced. We were told about it on March the 17th, and everything went into effect on March 18th. So those developers that had actually got signings lined up with purchasers had to shelve it and find ways of maintaining contact with those purchasers. The immediate consequences of the lockdown meant that contracts remained unsigned, documents that were meant for stamping had to go into a pile and for us to sort out with the stamping office. Luckily for us and for quite a few lawyers, I think we are on e-stamping, so we could still attend to stamping of documents from remotely from our homes off-site, but we could not do land registry presentations or filings in the High Court, which resulted in loan releases being held up. So this affected cash flow of developers and also affected the cash flow of us as lawyers because we couldn't get our bills paid. So immediate steps needed to be taken so that we could actually get up and running as quickly and as safely as possible. So what we tried to do and what we managed to do with some banks was ask them to look at their SOPs to see how they could actually modify it without taking any risks so that we could actually proceed with documentation while we were off-site, while we were at home. Lawyers were at their houses, the clerks were at their houses, the developers were in their houses as well. So what we did was we did the e-stamping, and luckily for our firm, we have a very good IT department that got us very quickly connected through VPN to our J drive. So we had access to our scanned documents and we could actually work with the banks to actually do some advice release during the lockdown. But the banks that we could actually do this with were CIMB and Public Bank because they accepted our documentation on the undertaking that the original documents would be forwarded later. So we sent scanned documents. And most of them were very helpful with regard to that. Next slide, please. The other issues that had to be resolved during the pandemic was that we couldn't do online searches. Currently, I think JKPTG is trying to do online searches with the various states, and there are, I think KL is already online for searches, but the rest of the states, and I understand Johor is only coming online for land searches in 2023. So that needs to be resolved. Otherwise, if another pandemic happens and if we have another lockdown, we are actually going to be stuck again. Because if we can't do presentations or registrations at the land office and the High Court, we can't advise release, which means the developers can't get access to progressive payments for banks to release it to them. And government is actually looking at 3 to 5 years with online presentations at the land office, and we're hoping that they keep to the schedule or can make it actually a little bit faster. The other problem that developers had is execution of documents. The developers wanted to lock in the purchasers to commit to the acquisition of units, but the purchasers couldn't be physically present either at the developer's office or at the lawyer's office. And a lot of them couldn't have access to third parties to witness these documents, the signing of the documents. I think developers were willing to do virtual tours and remote execution of documents, but the issue was how do we make these documents valid if the usual process of having a lawyer attend to the signing couldn't be done during a lockdown. Next slide, please. So we looked at how video conferencing could be used, or electronic signing signatures could be used during such situations where we have complete lockdowns. During the movement restriction, it's okay because you can actually attend to the purchasers, or they can attend before the solicitors or commissioners for oath. But during the actual lockdown, everybody was just frozen where they were. But business still had to go on, or you would be facing extreme cash flow shortage. So we looked at the jurisdictions, neighboring jurisdictions, and Singapore has actually got an Oaths and Declaration Act where Commissioner for Oaths can actually do attestations by video conferencing, but they have to actually in practice make arrangements which are acceptable, and there are certain safeguards which are actually provided for in the Act. Australia worked really hard and very fast, and they actually came up with the Electronic Transactions Amendment COVID-19 Witnessing Documents Regulations 2020, which came into force 22nd April, very fast. And it's, I think, valid until September, and they may extend it. UK doesn't have the same regulation in place to take into account of the lockdown, but they are looking into permitting video witnessing of electronic signatures. Unfortunately for us in Malaysia, the law is silent and there's no enabling legislation for video conferencing. And the Bar Council has taken a conservative approach, but leaves it open to solicitors to take a different view with independent legal advice. So what does that actually mean for the rest of us, right? Next slide, please. If you look at the various states, as I've said, Singapore is actually looking into it. The Commissioner for Oaths can actually administer oaths and declarations. Australia has their regulations, which allows for video conferencing, except for certain documents like powers of attorney, deeds, SDs, and wills. So there's certain documents that can be witnessed with video conferencing and certain that cannot. For Malaysia, virtual witnessing, our view is it should only be considered if a face-to-face attestation is impossible and proper procedures and steps are taken to minimize the risk of it being disputed. What do we mean by that? It's like, next slide, please. Before I come to this slide, sorry, go back to the, yeah. What we mean by that is that if there's any risk that the purchaser is going to say that he didn't voluntarily sign it, or he was coerced, or he didn't understand, then the execution of that document may be disputed. The other possibility is e-signatures. Next slide, please. But the problem with electronic signatures and digital signatures is you still need a witness to be physically present, who can also sign it electronically, but they need to be physically present when the person who does the digital signature or electronic signature is doing so. So it doesn't solve our problem of having, not being able to have a witness physically present there. So for the purposes of the developers in a lockdown who want to have agreement signed, electronic signatures, we think, will not be your solution. Plus, electronic signatures and digital signatures need to have the approval of the Inland Revenue for stamping purposes, and currently there are no directives that actually recognize it. So we would not be able to use it for our sale and purchase agreements and our deeds. Next slide, please. So what we are suggesting is that it should only be used in a situation where there's no alternative and it needs to be signed by a certain time. It should not be used in a situation where you can actually have access to a commissioner or a third party individual or a notary public, and it should not be used because it's a cheaper alternative. which most purchasers will tell us, you know, it's so expensive to go before a notary public. Can you just sign it, without me being present? That's not a situation where we would advise it. And if you do use video conferencing, it would be to explain to the purchaser the terms of the contract and to make sure that they fully understand it. We would have to make sure that the risk of it being disputed is minimized, and we would do that by following certain steps. Next slide, please. So we would have to personally verify by visual inspection that the person who is appearing before us in the video is the person that is actually the signer, supposed to be the signer of the contract. We have to confirm that the document he has and the document that we are referring to is the same one, and that there's no difference in the pages for the document that is required to be signed. You have to maintain visual contact with the signer throughout proceedings. And you have to, we would suggest that you have to collect clear evidence of his presence and him being alone in the room that he's signing without anybody forcing him to sign the document. The recording has to be properly documented and archived. And more importantly, we would suggest that corroborating evidence with regard to him requesting for video conferencing be collected and be robust, so that he cannot dispute later that he asked for video conferencing and that he was willing to be bound by the agreement. So notes of the whole proceedings before and after have to be documented and recorded. Next slide, please. Okay, so basically what we are saying is no to video conferencing unless you really cannot have any other situation. And if you do, safeguards must be in place. The lawyer has to make sure he is speaking to the right person, that the right document is being put in front of the person who is signing it. It was at his request and there was no other alternative. The document is still valid if it is signed by both parties, depending on the type of document. There are some documents that are required to be witnessed by specific people, and in that case, video conferencing won't work. Thank you.
Thank you, Sunita. Thank you. That's very informative. Hopefully, you know, we will progress very quickly to have, you know, all these measures in place so that business can be as usual. Actually, Dato Mukris at the Dewan Rakyat sitting a couple of days ago asked whether the government will introduce an act to protect companies and individuals for failing to fulfill the terms of an agreement or contract as a result of the COVID-19. So our Prime Minister's Department's Law Minister said that the drafting of this bill, which is called the Temporary Measure to Reduce Impact of COVID-19 bill, is at the final stage, and they are hopeful that, you know, it will take effect September. And our minister, finance minister, said that, you know, this bill will mirror what New Zealand and Singapore has passed, the law that has passed in Singapore. So hopefully we have all this in place, and then if there is another lockdown or, you know, things like that, you know, we can, you know, use it to keep the business going. So next we have Karen Lim from Kuala Lumpur to walk us through some of all these dilemmas of the landmark case of Ang Mingli, which says that the housing controller has no power to extend the 36-month period for delivery of vacant possession of residential units under the HDSPA. So let us welcome Karim.
Hi, good afternoon, everyone. I will quickly run through the cases so that Dr. Paul can finally give us the answer to the question posed in our title. Okay. Like Lina said, the Ang Mingli case caused major concerns with all housing developers. It does not apply to commercial units because this is for those that govern under the Housing Development Act. So briefly, the facts of the case are that the developers signed SPAs with buyers back in 2012. 2 years into construction, the developer applied for extension of time. in 2014. So obviously the buyers are not happy because, the extension of time was granted, buyers not happy, and they sued. So the crux of the federal court, it went all the way up from High Court, Court of Appeal to the federal court, and the decision of the federal court is on your screen. So it says that the regulations is ultra vires of the Housing Development Act. Because the minister has no power to delegate his power to the controller, it was the controller who granted the extension of time. So because the minister has no power to delegate his power to the controller, the regulation is ultra vires of the act. That is the crux of the case. Not when it was granted, whether it was prior to execution of SPA or whether it was in the middle of construction, it was a point of law. Okay, next slide. So it also emphasized that the importance of the HDA as a social piece of legislation, that the HDA is to protect buyers' interests first and foremost, as our Minister of Housing has been emphasizing all this while. Okay. So because of the case, amendments to the prescribed statutory SPA, whether it be Schedule G or H or I or J, can only be approved by the Minister of Housing by seeking a Section 2.2 exemption. Okay. That on your screen, that is what Section 2.2 of the HDA reads. Okay. That is the snapshot, the reproduction of the Section 2.2. Next slide, please. Okay, what Ang Mingli did not answer is whether the decision is retrospective or prospective. Prospective means moving forward from the date of the date of the decision. Retrospective means whether it applies to all those situations where EOT has been granted prior to the decision of the federal court case. So in Alvin Leong, the following two cases, this case is a High Court decision. So in Alvin Leong, it was held that the facts of the case are similar to Ang Mingli, and the High Court finally answered the question that most people are asking, and the answer was that it has a retrospective effect. So, of course, having a retrospective effect, it caused even more concerns with all the developers, because what are we going to do now for all those extension of times that we have been granted by the controller? Right. So next slide. Okay, this is a very strange case. This case was decided this year. So the question is whether we can distinguish Ang Mingli, bearing in mind it's a federal court case. So the decision in Echo Green, it was held that they tried to distinguish Ang Mingli by saying that the extension of time was granted prior to any SPA was signed. So by the time the first buyer signed the SPA, the completion period was fixed at 36 months instead of 24 months, right? So my personal view is that this case should not be followed. It is not in line with the decision of Ang Mingli, because Ang Mingli states that the crux of the matter is that there is a flaw in the HDA, or in the by not granting a controller, by not giving the minister the power to grant the controller the power to grant extension of time. So whether, like I said before, whether it was granted, the modification was prior to signing of the first SPA, or whether it was middle of the construction, it does not matter. So even though this Echo Green case tried to distinguish Ang Mingli, my view is that Ang Mingli position still holds, and that if this goes on appeal, as of now, there has not been any appeal yet. If this case goes on appeal, I am pretty sure that on appeal, the decision will be reversed. Okay, that's it for me. And now I think we move on to Datuk Paul, whom everything is waiting for with bated breath.
Yes, thank you, Karen. Yeah, so is it a crash landing or is it a cash landing? Let us welcome Dr. Paul Kong.
Thank you, Lena. Good morning to all guests. I think Lena has gone through my CV, my entire CV. So next time, I think I must shorten the intro. Okay, my topic is the Malaysian property market and trends. I think I now have to minus off the legal process and the finer details. I think ZICO has done it already. So coming to my first slide. Our property market has started at a very slow start in 2020, right? And we had an overhang status of about 30,000 residential units valued at about 18.9 billion. We had a super whammy of events this year. We started off with COVID-19, the MCO lockdowns, the oil crisis, the trade war, and our political climate. We always have one problem above everyone else. Therefore, now you see all businesses and the property sector is taking a toll across the country. We hear a lot of hotels closing down. We have Plenitude talking about Mercure, Gurney Resort and Travel Lodge being closed down. And we have VOOC also talking about closing down Jazz Hotel, Penaga Hotel in Penang. We hear Swen Hotel closing down, Ramada closing down, and everyone seems to be suffering the same fate. Then we move on to the retail front. It is not very much better either. We have GNC, Zara, Esprit, Muji, Pizza Hut, and Hertz. All these brands are some of the brands that all of us have heard before, and these are either closing down or filing for Chapter 11 bankruptcy protection. Not very good news. And I think in terms of the airline segment, we have the same tone and same news coming through. Virgin Airlines, Air Deccan, Air Emeritus, and many, many more. Well, look at the bright side. On the property segment, we are not doing that badly. We still see, can I have the next slide, please? For the next, the segments that are still doing positively well are logistics, industrial, data centers, healthcare, and landed prices, plus the landed residential in good locations are still holding on very well. The local property prices have not fallen off the cliff at the moment, so don't worry, even though there's a lot of negative news around. The drop in capital value is largely not due to COVID-19. A lot of the properties have been performing poorly prior to C-19. So please note that the market has fallen since 2014-15 from the peak earlier. Property, next slide, please. Property valuers like us have also revoked the material valuation uncertainty clauses, and valuations now are valid for a shorter period. Market is evolving rapidly into uncharted territories. The worldwide pandemic is hitting us, and sales evidence in many markets where we do comparison methods do not give very big emphasis anymore. Valuers are adjusting to the market, and we are starting to impair values slowly. We are sensitive to market conditions, but we are still taking a conservative stand on values until such time that market heads southwards. I think all of us need to understand that property market is not as volatile as the stock market, but then we see the impact coming through direct at us. We do take a long-term view on properties. Just because there's 1 or 2 fire sales in place doesn't mean that a tsunami is coming. Next slide. I think for Malaysia as a whole, we have come out of the lockdown quite reasonably well. Prihatin was very effective, and it has helped short the market very well. However, I think the full impact will be seen after Q4 or during Q4 when this moratorium ends. I sincerely hope that the market will perform and allow businesses to catch up for all the lost times for the year. For Prihatin, Malaysia gave us a 6-month bank moratorium, and the actual lockdown that started in March 18 and the partial opening up in mid-May would have caused a lot more casualties if this measure was not introduced. I think the moratorium is effective. It has helped curb a lot of serious foreclosure action. So now you see that there's basically very nominal new public auctions by bank, and it has been well kept at bay. I think this has also helped us to delay the financial impact to the property market until after October 2020 and moving into 2021. For auctions to come through, it's always a plus 3 months. So I think all of us are still safe until year end. Of course, we still hope that when we hit Q4 in October, things would be more settled and the market will be well again. But I think this hope is rather slim. Recessionary times are coming back. I think what we need to do is to brave on into Q4, and hopefully with a strong balance sheet. I think cash is king. I think that will make the difference. The other worry that we have is basically COVID-19 is actually coming back. Melbourne has been locked down a second time. And hopefully, again, as I said, we hope that our shores are spared this time around. It is not good news if it's coming towards us. On the property side, I think ZICO and the lawyers have gone through all the benefits that has come through in Prihatin and Penjana. I'm also coming in on this angle as well, hopefully to see from the property side, what is it in for us. Penjana was announced in June 1st. It is very well released in a perfect timing to help to show up the residential market in Malaysia. Penjana gave us stamp duty exemptions, transfer, loan agreements, but subject to finer prints. I think ZICO has addressed that one. And for the HOC, the developers are now giving 10% or more in terms of discounts through to 2021. I think the RPGT exemptions were also given. We like this piece. RPGT was always meant to be an instrument to curb speculation, but it has since deviated from its original objectives earlier and was converted into an exit tax when any property that's sold is still subject to RPGT after a 5-year holding. Through Penjana, I think RPGT given to all Malaysians up to 3 properties is something that many sellers can now gain their profit safely by selling now. I think as far as the property market is concerned, especially the residential side, it is a big kicker. We hope to see some traction in the market moving down the next couple of months. The next, the relaxation of LTV, no more 70% cap on your third loan onwards. This will attract qualified investors that have stayed out of the market for a long time. Once the government enforced 30%, the third loan with a 70% cap the last round, many investors have moved out of the market, and therefore this instrument given to the property market will help spur investments back to the residential market. We hope to see some speculation element again to spur growth as far as the residential markets are concerned. I think this is an opportunity, a good one, to actually buy during the trough and at a very high LTV ratio. I think we move the slides further. I forgot about my slides. Okay, the other thing is that on this slide, what we are saying earlier is, earlier when we had an initial outlay of 100,000, what we could only buy is an apartment at 330,000 per unit. And at the same time, you have to pay transfer and loan agreement stamp duties on your own. With the latest LTV, you can actually, with a 100,000 outlay, you can buy a house worth $1 million and get exemptions for these 2 stamp duties if you pick it up from a developer. This will give the residential market a new breath of life. I hope the market continues to move up. Well, I do not know how long I've spoken. I possibly have exceeded my time as usual. Maybe after the last slide. Okay, as we all know, every property experts will tell you location, 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 and I think all of us are sick of it. But that's the standard mantra for all property buyers. But now I'm introducing another one. Buy low, sell high is a stronger mantra at this point of time because the market is offering very good bargains and we are currently moving into recessionary times. The property market is getting more attractive and we are seeing good deals surfacing towards the trough. a good time to start hunting for bargains. I didn't say buy, but moving down second half of 2020 and into 2021, I think there should be a lot of interesting deals to look at. Anyway, I think I should end. Good luck and happy shopping. Thank you.
Thank you, Dr. Paul. We are pressing for time. We have quite a few questions. Maybe we should quickly ask the first question to Sunita. Sunita, there's this question asking, is the agreement signed by parties valid if there's no witness to the signing or attestation by video conferencing if it's disputed? So is the contract still valid if there's no witness? Sunita?
Yes, good question. Because after all the hoo-ha about whether it needs to be witnessed by video conferencing or e-signature, generally in Malaysia, a contract is valid if there are two parties or more who are in agreement and have signed the contract. The witness is actually not a vital issue to the contract being valid. However, if there is a dispute in regards to any of the terms of the contract, the witness would be essential to show that when they signed it, this was the document that was signed and that the person who signed it was of sound mind and signed voluntarily. But as long as the terms of the contract have been agreed to by the parties, the witness is not material to the validity of the contract unless legislation provides that you need to be, the document needs to be witnessed, like under the National Land Code, your Form 14A, your Form 15A needs to be signed and witnessed. Power of attorneys need to be witnessed in accordance with the Power of Attorney Act. Wills need to be witnessed properly, otherwise it may be invalid. So if there's no specific legislation for normal contracts and agreements like sale and purchase agreements, the parties need to be in agreement. The witness is not vital. However, if there is a dispute, then the witness becomes material. What we would suggest is if there is no witness, then your documents need to be and your correspondence need to be in place to show that parties had agreed to those terms and they are stopped from denying it. And generally, if parties have already complied or are in compliance with the terms of the agreement, like payments have been made, that shows that the contract is valid. So I would say the witness in certain contracts are not required, but where it is provided for the witness is essential, then you have to have the proper witnessing.
Okay, thank you, Sunita. There are still 11 questions to go, but perhaps maybe I just ask one last question to Karin. If I have already obtained a letter from the Ministry of Housing granting my company exemption pursuant to Section 2.2 of the HDA, can I start selling the units in my development? Karin, are you there?
Yes, I just
Yeah.
unmuted myself. Yeah, the short answer is no, you can't start selling because the exemption granted by the minister requires it to be gazetted. So until and unless the exemption is gazetted, developers can't start selling their units because the exemption is not valid until it is gazetted.
Oh dear. Okay.
Yeah.
So looks like it's going to be quite tough moving forward, right?
Yes,
Big
but there
projects.
are talks that the Housing Development Act is currently being amended. Pemuda is in talks, and the Housing Ministry and REDA as well has been in discussion on the amendments of the HDA. Hopefully that will be pushed through soon. And hopefully there is also something in the COVID-19 Act that is going to be enacted soon to address this.
Yeah, okay. Thank you very much, all my panelists. We had fun. And thank you participants as well for tuning in. The recording will be made available to you and our BDCC team will send it across. Okay, thank you everyone. Have a nice day. Bye.